as was noted, this is before the board on two related filings, a substantive validity challenge, an appeal from a permit approval that was issued by right by the township to Rex Energy for construction of an unconventional deep shale formation natural gas well on the Geyer tract. Both appeal and the substantive validity challenge arise out of the decision of the Board of Supervisors on August 13th of this year to revise its zoning ordinance. And in revising its zoning ordinance, the evidence that you will hear will demonstrate that the board violated its obligations under both its own ordinance. It violated the statement of community development objectives.
Excuse me, sir. Can we turn the cell phones off, please? Thank you.
Wait, let's just take a break. I'm sorry to interrupt you. Everybody, turn your cell phones off now.
Probably.
Yeah.
It wasn't him. It was him. Everybody's phones off. All the people whose phones should be on would be an emergency responder. Everybody else's phone should be off. Sorry.
No, thank you. I appreciate it.
At least it wasn't mine.
Yeah. I've had that with the judge, critiquing folks and then having them own them. The change in the township's ordinance is being challenged both for its inconsistency with the township's own ordinance and own comprehensive plan, and for its violation of the municipality's planning code and the Pennsylvania Constitution. Now, as this board knows, and board members have been serving in these capacities for a long time, the zoning is carried out under the municipality's planning code. And for zoning to be lawful, for zoning to be constitutional, it has to reflect a balance of community interests. And you can't enact an ordinance that disrupts that balance and that puts the interest of one property owner or one set of property owners in front of the interest of the community as a whole. Now, that is a basis of zoning that goes back to the origins of zoning and to the recognition that for zoning to be constitutional, it has to be related to the public health, safety, and welfare. And zoning ordinances that go against that interest, the board and ultimately the courts have the authority and the duty to strike down. And so we look under the municipality's planning code at what is required of a zoning ordinance. And the zoning ordinance is required to balance those community interests and to put compatible uses with compatible uses and to separate incompatible uses. That's part of how you protect what's called a reciprocity of property rights. That you have a right to do on your property what you want so long as it doesn't interfere with your neighbor's property rights. And if you allow incompatible uses to go together, if you allow a heavy industrial use, for example, to interfere with residential property rights, you're violating the property rights of those residential neighbors. And you are enacting an ordinance that undermines, that's irrational, that undermines the whole reason that zoning becomes constitutional. And there's nothing new about that in the law. That is zoning 101. And the way you go about determining whether a use is incompatible is you look at the nature of the use. You compare what the use will entail with what's in the comprehensive plan and what the comprehensive plan contemplates for the land. You look at whether community-wide there is an appropriate balance between allowing development and protecting property rights, protecting the public health, safety, and welfare. The Commonwealth Court for decades has addressed, and the Supreme Court has addressed these issues and says if a zoning ordinance is incompatible, an ordinance amendment that's incompatible with the own purposes of the ordinance, if you have an ordinance amendment that gets the balance wrong, the courts will strike it down. So you will hear evidence about why Ordinance 127 is incompatible with the purposes that are recognized under this zoning ordinance, with the community development objectives that are recognized in the township's ordinance, with the joint comprehensive plan that this township has entered into, and with basic zoning principles that are expressed in the municipality's planning code. You will also hear evidence then about what the nature of the use is that's being allowed. You'll hear evidence about the nature of the chemicals that are used. You'll hear evidence about the nature of the materials that are brought to the site, about the nature of the equipment that's brought to the site, about what the off-site impacts, what the hazards associated with those uses are, and what the off-site risks are associated with those uses. And that's part of what you're mandated to do to reach your conclusions about compatibility and about consistency and about balance. Now, on top of that, those what I call zoning 101 principles, the courts have also recognized that we have a Constitution, and that the Constitution has meaning, and that when the Board of Supervisors acts, it has to respect the Constitution. The Board of Supervisors can't pick one part of the Constitution to respect and ignore another part of the Constitution. And so we have a section of the Constitution, Article 1, Section 1, that protects property rights. And the Commonwealth Court of this state and the Supreme Court of this state has recognized that if you unreasonably disrupt the expectations that are established by a zoning ordinance, by enacting an ordinance like Ordinance 127, you are violating those constitutional principles under Article 1, Section 1 of the Pennsylvania Constitution, which provides the residents with that reciprocity of rights, with that recognition that they have a right to their property being protected as well. There's another section of the Constitution that also has to be given meaning, and that's Article 1, Section 27. Article 1, Section 27 is often referred to as the Environmental Rights Amendment, and it states that the people of this Commonwealth, including the residents of Middlesex Township, have a right to a healthy environment. And it says that all branches of the Commonwealth, including municipalities, have duties as trustee to protect and maintain those resources, not just for their use today, but for future generations. And that when carrying out those constitutional obligations, the supervisors, as government officials, have to respect the Constitution. They took an oath to do so. And in doing that, there are requirements about how they do it. They're required to assess whether what they're doing will cause an unreasonable degradation of the public health, safety, and welfare, and the environment that we all have a right to. And this case will demonstrate that by turning approximately 90% of the township into an area that can be industrialized, this board got the balancing wrong. This board has violated not just the municipality's planning code, but the constitutional rights that are protected under both Article 1, Section 1, our property rights, and under Article 1, Section 27, our rights to a clean environment. So there's going to be a lot of testimony. Some of it is going to be technical and expert in nature. The majority of it will. And I thank the board in advance for your attention.
Thank you, sir.